Jibai, my lord. My lord, if I may be allowed to make a
For the 5 minutes delay. Yes, Mr. Tlianga?
if I may be allowed to make a mention from part 2, my lord.
Part 2?
Item 7, my lord. This is a POXO appeal, my lord.
Yes.
If this matter can come up after the vacation, my lord. I've taken the consent.
1 second. The part 2 list gone. List. I don't know why they keep everything. Item 7.
My lord.
As prayed for by Mr. C. Tlianga, learned counsel appearing for the appellant, which is not opposed by the learned counsels appearing for the respondents, relist after 3 weeks
My
on a
lord.
date to be fixed by the registry. Yes.
Obliged, my lord. My lord, similar prayer in item 10 and 13, my lord.
All right. Same. Next.
Obliged.
My lord, regarding item number 15 of part 2.
Yes.
Yes. On behalf of my senior, Mr. Bill Ramenga, who is the amicus in this matter.
Lara Manga.
Yes, my lord.
As
If the matter
prayed for by Mr.
Lomo Maralte.
So and so, learned counsel on behalf of Mr. B. Lal Ramanga, learned amicus curiae, which is not opposed by the learned APP. APP, na, in this case, 15. Learned,
My lord, Miss
MS
Vani is
Linda,
there, but please don't look.
Learned PP, sorry. Learned PP for the state of Mizoram, relist after 3 weeks and a date to be fixed by the registry. Yes.
Obliged, my lord.
Daily list for admission, item numbers 1 to 6.
My lord, regarding item number 1 to 6, as per the last court order, Chief Engineer Project Puspak and Mr. Sugdar Sharma, Assistant Engineer, has been called for personal appearance, my lord.
Who has been called
My
for
lord,
personal appearance?
if I may, now at that time, respondent number 9 is Chief Engineer Project Puspak, namely Kople. However, thereafter, we have another chief engineer. Now, we have a new engineer. Even that was not yet pleaded. If I may permitted by your lordship permission, the new chief engineer, who is not now a party in the case, may appear before the court.
Is he here?
Yes, my lord.
Yes, but before we hear him, so as per the order dated 13/11/25.
Yes, my lord.
So under this order, who was supposed to appear today? Mr. Sudhakar Sharma.
Chief engineer and Sudhakar Sharma.
And
Assistant engineer.
Is the assistant engineer here?
Yes, my lord.
He is here. You are there?
Both are them.
And no, both means the
Chief
then,
engineer.
the then chief engineer project Pushpak is also here.
Yes, my lord.
Who is he? You are there. So give your Michael, please have their names. That's all right. Please take your seat. You are Mr. Rajesh Dua. And you are Mr. Sudhakar Sharma. All right. Yes, what is the, you are for the petitioner?
My lord, I am for the petitioner.
What was the non-compliance alleged?
My lord, if your lordship could kindly come to the last order, which
Yes.
was passed on 13/11/2025.
Yes.
My lord, shall I read out the whole orders?
No, what is the non-compliance? Please tell me in brief, what is the non-compliance? What was the operating part of the order and what has not been complied till date?
My lord, the reason why the present assistant engineer and the chief engineer were called are reflected at page number 15 of the order. Now,
All right,
instructions.
let me read
yes,
this order.
Specific
You're not
instructions.
helping the court. Let me
My
read
lord.
this order.
Specific orders were given.
1 second, let me now read. Yes, Mr. Sharma. You have given this instruction dated 12/11/2025. Correct? Can you please come this side? You see, Mr. Sharma, you are aware of the facts of the case.
Yes, sir.
Correct? You are aware of the decision of this court passed in WPC 129 of 2018? The order dated 28/5/2019. What does the order say? It says that there has to be the acquisition proceedings has to be completed, a time limit has been given, a verification has been, an exercise has to be taken, correct?
Sir, but due to some correction, sir, due to some correction from award,
There has been some, you have noticed some multiplier factors have been wrongly taken.
yes, yes.
That is why you wanted it to be re-verified and you
And-
have kept the award in abeyance, correct?
The events means due to time to time change in award, amount of awards.
Are you comfortable in English? Are you comfortable in English language?
I know Hindi.
You are comfortable, right?
Yes.
Or you want me to speak in Hindi? That's why I'm asking.
Yes, sir.
See, Mr. Sharma, there is an order of the High Court. है ना?
Sir.
Order is very clear. Now, if there you have any difficulty in complying with the court's order, you can always come up with an extension application or with an application seeking time or saying that it is impossible to comply. But what appears here is that for so many years, an order which indicated a time frame has been not complied.
Sir, I have already intimated, sir.
Huh?
But due to frequently change in amount of the award, final decision not taken by this department.
नहीं अभी final decision कब ले सकते हैं? When can the final decision be taken, Mr. Sharma?
Sir, our department is agree to comply the award, sir.
Now, what is the difficulty then?
Sir.
What is the difficulty? Because the petitioners are waiting since 2019.
Sir.
We are in 25, end of 25. There is an award in their favor.
Sir, award received 29 May 2025.
So why it has not been complied till now? Why it has been kept in abeyance? Under what provision have you kept it in abeyance?
Sir, due to frequently changing the amount in award, I
You
cannot.
see, I need a specific instruction by when can, because you have not filed any appeal against all these orders also. Now you have to comply with it. If there is some re-verification, you are doing it, that exercise has to complete and finally the payments has to be done. Because the land of the petitioner has been acquired,
Yes, sir.
yes or no? It has been acquired.
Yes.
So if it has been acquired, the petitioner has to be compensated. That compensation the petitioner has not received till now. Despite there being a judicial order of this court way back on 28th of May 2019. This court is only on that. You see, there are remedies open. If you are aggrieved by the orders of the High Court, remedies are available. You can take recourse to appeal, you can take recourse to review. But one cannot sit over the orders passed by the High Court in this manner. It appears for a long time this order has not been complied. There can be some difficulty. I am not saying that there is no difficulty. If there are difficulties, you let us know. You file application, you seek for extension of time in complying with the court's order. But what is noticed is that nothing of these sorts are being done in these contempt proceedings. The court has a difficulty when the court's orders are not being given the due respect which
Yeah.
it commands. That is the problem. You see, the fact that today you all are
Yeah.
sitting here is because of that, because this, sufficient explanations are not coming forth before the court.
Sir, I apologize for that, sir.
No, that's all right. But now, what is to be done? Your senior is also here,
Yes.
isn't it? You are the executive engineer. You are the assistant engineer.
Assistant engineer.
And who is the civil engineer? Mr. Rajiv Dua. What do you have to say?
Sir, there is no willful disobedience of the court order.
That is a defense. I'm not asking about your
Yeah,
defense
there-
right now.
There's no problem.
You see, we are trying to find out a way of how to get these orders done, complied, because you have not filed any appeal or anything. There has been a long delay. Now, please tell me how you, by when can these orders be complied?
We have already.
I'm not at this moment. I'm not adjudicating whether there is a willful disobedience or not. For that, your lawyers are here. We want to know from you what is taking time and how much more time is required. Simple question.
Yeah, sir, I would require about 90 days after we receive a clarification from DCCI that whatever calculation they have made, it is correct, because our head office is asking us a question, please confirm the correctness, which we have already asked from DCCI. So after we get the clarification from them, we will be processing the case, we will be reaffirming the case which we have already moved on 24th of November, and then perhaps it would take about 90 days for the payment to be made.
This stand is there on writing? No. Any affidavit filed before this court where this stand has come, Ms. Sangpui?
My lord, they prepare letter, one letter.
From the Deputy Commissioner Siha,
Sir,
as regards the exact amount.
sir.
So, who is appearing for the Deputy Commissioner Siha? Anybody there, Miss Mary?
With due respect, Your Worship, clarification was sought by the BRTF. It was sought in March 2025, and correction of award was already intimated to Officer Commanding 71 RCC on 27th March 2025, which I have annexed and given a copy.
27?
27th March 2025.
This was the clarification given.
6 November.
Yes, after that, they have again request to provide a boundary map, which I do not have the information.
So, you give whatever is required. We will take note of the submission made today in court.
Yes.
We'll ask them to also put this by way of an affidavit. And in the meantime, Ms. Mary, you let the Deputy Commissioner know that to immediately give them, and we will also put it in the order that they must, all the concerned officers must seriously look into the matter and work in together to comply with the court's order. All right.
Yes.
So whatever is to be done at your end, you do it. I think they only need the boundary map now. But once the award comes, why the boundary map? The award must.
Yes, exactly, Your Worship. There has been several queries that is made from time to time. I don't know whether it's a delay tactic or not. But then after one another, they have made a request for this and that, this and that. It's always answered. Now, since this is not in affidavit, I do not have the information of this.
So I'll ask them to put this by way of an affidavit, and we'll give another last chance, but we'll make it clear that this cannot go on. All right. And Ms. Angpui, you said another officer is here, somebody who has to be made a party here. What I didn't understood. What was that submission of yours?
The new chief engineer.
He is the new chief engineer. So by name he is not in this matter. That's what you are saying. So the earlier person who by name was arrayed is no longer holding the post of chief engineer. That is contender number. So in place of number 9, Mr. Dua has taken office. In the meantime, I think you may have to bring Mr. Dua on record that you do whatever you do. Ms. Dinri?
Yes, he'll do that.
All right.
Your Lordship, item
Yes,
number
Miss
1 through 15.
Dinari?
It's, item 1 to 15, it's a same order, similar matter.
All right.
Appearing from 2 to 4.
I'll just
15, yes.
take it, wait 1 second. All of them together. Huh? Heard MS Dinari, T. Azul, Learned Council appearing in item numbers
2 to 15.
2 to 15. And Mr.
Tila Sakima in item
So
number
and
1.
so learned counsel appearing in item number 1. Also heard MS Sangpui, learned CGC, and MS Mary, learned additional learned counsel appearing on behalf of respondent numbers 12. And CGC is for 3, 7, and 9. 3, 7, and 9. Pursuant to the direction passed by this court on 13/11/2025, Mr. Rajiv Dua, Chief Engineer CP Pushpak, and Shri Sudhakar Sharma AECP Pushpak are personally present in the court. Mr. Dua, by referring to a communication dated 4/12/2025, submits that the office is not in a position to make payment on award number 12 of 2024, as the clarification regarding the exact amount to be paid as compensation is still awaited from the Deputy Commissioner, District Siha. He further submits that once the aforesaid clarification is received from the Office of the Deputy Commissioner, District Siha, the payment process will be initiated without any further delay. He further undertakes that within a time frame of 90 days,
Yes, sir.
the department shall obtain the approval of the HQ Directorate General Border Roads for complying with the court's order upon receiving the necessary clarification on the compensation amount from the Deputy Commissioner, District Siha. Stop. MS Mary, learned counsel appearing for the Deputy Commissioner Siha, within bracket respondent number 12. 12, right?
Yes, Your Honor.
Respondent contemporary 12 submits that on 27/3/2025, the Office of the Deputy Commissioner Siha had already given the clarification as regards the payment to be made to the petitioner. She further submits that time and again the officers of the they are officers of the border roads, right? Of the border roads, I have been seeking clarification, and as and when the clarifications are being sought, the office of the respondent number 12 is duly complying with the same. Mr. Dua further submits that on November, which is that letter you said?
6 November.
On 6/11/2025, the Office of the General Reserve Engineering Force, BRO, had written a letter to the Deputy Commissioner, District Siha, requesting to provide boundary map for urban areas of Siha District to verify multiplication factor applied in award number 12 of 2024. Let a detailed affidavit placing the aforesaid documents and the time frame within which Mr. So-and-so has undertaken to comply with the court's order upon receiving the clarification from the Office of the District Commissioner Siha be filed within 1 week The affidavit can be filed within a period of 1 week, from today. Ms. Mary so and so shall also obtain instruction from the respondent number 12 in this regard. It is observed that despite the order dated 28/5/2019 passed in WPC number 129 of 2018, the award number 12 of 2024 has not yet been complied. It appears that this court on 13/11/2025 has already taken a prima facie view that the respondents are trying to circumvent the order the order dated 28/5/2019 passed by this court. Be that as it may, before further proceeding with the matter, this court gives another chance to the respondents to be that as it may, before proceeding further with the matter, let the affidavit be filed on record. Give a time after you said 90 days. That's a long time.
We have to go through number of processes, like doing from here, then going to.
Anyway, I'll fix it after the reopening. Let me fix it in the month of end of January. Let us see what happens till then.
Right.
Last week of January, relist on so and so,
27th of January.
by which date the up-to-date instruction as regards the compliance of the order dated so and so shall be placed on record also. It may be clarified that there being a positive direction from this court for making the compensation to the petitioner in terms of the award number 12 of 2024, against which there being no appeal filed till date, the same ought to have been complied by till date. However, keeping in mind the procedural clarification sought for in the matter, the court is not making any comments at this stage. However, in the event this court finds that the respondent contemners are deliberately adopting dilatory tactics to circumvent the order of this court dated so and so, this court shall take necessary stringent action as required under the law for protecting the majesty of this court. I've made it very clear. So please try seriously to sort out the issue. You may seek your clarification, but you have to understand that a long time has gone. Now you want a boundary map. You want to compare. There is an award. The exact amount is given under the award. It doesn't, you see, at the end of the day, it is looking like perhaps your stand is not bona fide. Today, I am not adjudicating the matter. I have given you a chance to put it on an affidavit, but I am expressing my mind. There are already 2 orders of this court on record, where on both the occasion, this court have expressed a prima facie view that it is appearing that the orders of this court are being circumvented. Because you see, you might need clarification, I'm not saying. But what is this clarification after clarification? Now you want the boundary map. There has been a verification, they have verified it. You have already sought for clarifications way back in March. Those clarifications have also come. Now you want the boundary map. It doesn't appear to be very bona fide, Mr. Dua. But nonetheless, I am not getting into this right now. I'm expressing my mind so that you take up the matter seriously with the higher authorities that's required. All right, Mr. Sharma? So, personal appearance of the contemners at this stage is dispensed. However, at a subsequent stage, if required, the necessary orders shall be issued. At this stage, we are dispensing it. Please ensure that the affidavit is filed within the period of 1 week. All right, Mr. Dua, Mr. Sharma? Yes. Thank you. And you return this, Miss Sangkwi. You take back this, but you give a copy, huh? Make a photocopy and give it.
Yes, my lord.
This instruction and file it.
Yes, my lord.
Much obliged.
Item number 16.
Item number. Yes. Ms. Fanai, what is this criminal petition?
My lord,
First time
no,
No, my lord.
This not a-
Second time.
notice issued.
Yes.
yes,
Some instructions you are supposed to obtain.
Yes, my lord. This is with regard to the reduction of the bail bond and the sureties, my lord. The surety at number 2, my lord, condition number 2, at page 10.
দেখা সেইদিনা যে এটা দিছিলো এনেকুৱা কাৰ লগত আছিলে এইটো অনাই লচোন এইফালে গুচি যাবা এইফালে আহি যাবা পেজ
Page number 10, my lord. Para 5,
yes
this is the condition, and the condition number 2 is one surety shall be any one of the family members of the accused. This,
Yes.
they have difficulty in producing one family members. My lord, I have inquired with the trial court, and it seems if they are from Myanmar, they insist one family members means residing in the same house. Otherwise, there is danger of absconding. That
no
is,
but if there is none if they don't have then
my lord, he has an auntie in Aizawl. His mother had passed away, like the mother's sister is there. However, they don't have any documents because Laltan Lu, the instant petitioner, they reside in that part of Myanmar.
so this is the only condition they want a reduction or also of 2 lakhs
My lord, we had asked
1,
for
2 and
reduction
4.
of bail bond
1
as well.
2 and
4.
so 1 and then 2
Two is the family members.
member.
Bef-
And 4 is what? You don't have any Aadhaar and driving license. You don't have anything.
My lord,
yes, my
now-
lord, we don't have.
Now all the refugees, my lord, they are given some identity card.
My lord, if we may submit the Myanmar ID card, identity card, but it's written in their dialect. But
Is
then we
that-
can
will
translate.
that be okay? You see, now, Ms. Fanai, the difficulty is that bail bond conditions in these NDPS matters are also important. You are given bail. However, the court has to also ensure that you are available, you participate in the trial. In order to ensure your participation, these conditions are given. It appears you are not from here, you are from
Yes, my lord.
Myanmar.
Yes, my lord.
Now, how do we secure your presence? We have to, this court has to give. At the same time, it is also right that if suppose the bail bond conditions are too serious and stringent, it will be no bail. This
Yes,
court
my
is
lord.
aware of the principle, but at the same time, a balance has to be done.
Yes, my lord.
Now you say you don't have a family member. You say that 2 lakhs is also a lot. Then you
2
say,
lakhs, my lord, 2 lakhs and 2 sureties. So that means 4 lakhs.
Then you say that you don't have any documents except documents issued at Myanmar. So
Yes.
what is to be done?
My lord, in our prayer, we had asked a reduction of bail bond to 30,000. My lord, if that's too less, then maybe
That is
at
obviously
least
too less.
if it may be come down to at least 1 lakh each, 1 lakh each.
That we can make it 1 lakh. There is no difficulty. That we can do it.
Also, my lord, regarding bail condition number 2, we had asked the trial court that we will execute an affidavit stating that we are family members and that I will be responsible by the bailer, the auntie. But they said that before we used to execute affidavit, but nowadays they did not accept that affidavit.
Why?
That is why we don't know. That's why we approached this honorable
So
court.
you are saying bail condition number 2 may be allowed to stand as surety as family members of the accused, and an affidavit in this regard be accepted as proof of familial relationship. And this particular auntie, Lalan Feli, is from here.
Yes, my lord. She has
So
everything.
that is all right.
Yes, madam.
She'll give her affidavit. She has no documents.
She has documents. The auntie has documents.
So she
But-
will also give her documents.
Yes, she will give everything.
To stand as surety as family members of the occupant and an affidavit in this regard, the executing the said. So that is all right.
I think that is all right. If
That
they,
is-
yes, if they don't have any other family members.
Correct. This is sufficient, isn't it?
My lord,
And
number
yes,
4.
For what could be the problem? Because if the sureties is a resident of Aizawl, then she will have all this Aadhaar card, Epic card.
correct.
My lord, he has Myanmar.
No, the
I-
sureties would be the aunt, na?
Yeah, surety has it, but sureties and the accused.
Accused, my lord, they are given some identity card. All the Myanmaris, they are given.
So that
some-
will be sufficient.
That will be sufficient.
In case of the accused, that will be sufficient. Identity card issued from, in lieu of the applicant's Aadhaar card, EPIC card, driving license, and Myanmar identification card be accepted. So that should be sufficient. Right? Page 6. Yes, Miss Linda.
My lord,
You want to take instruction or something?
my lord, I don't think instructions will be required in this regard because as far as my knowledge is concerned, my lord, all the refugees, all the Myanmaris, they are given some form of identity card by the government, Mizoram government.
So then I say in lieu of the identity card issued given by the by the government.
But now they are saying they do not have that identity card.
Why? You are illegally staying here then.
Before, my lord, there used to be some village. There's a committee on some refugee, and the chairman was the deputy commissioner, and the members are the local council. The village council
Ms.
members
Linda,
are
can
there.
we do it like this? Can we say that as far as the surety condition number 4, let the trial court reconsider and to whatever let them be satisfied. Why should this court specify?
That's all.
Right?
Yes, my lord.
Because now these are the bail conditions which this court have already given, isn't it? This is this court's order, right?
Yes, my lord.
No, the bail was given by whom?
By the trial court.
Oh, bail was given by the trial court. You have not approached before the trial court for modification of the bail conditions, have you?
We had asked, but then
Where is that rejection order?
my lord, we were informed that I cannot make amendments to my order. You have to approach the Honorable High Court. That's
Can
why
we
we
not direct the trial court to reconsider these 3 conditions in light of the difficulties averred in this petition?
Yes, your lordship. I think
And we may emphasize that the principle that harsh bail conditions in a particular situation will amount to no bail. I think that should be sufficient if we do that. What do you say, Miss Linda? Because they shall be in a proper position
Yes, my lord.
to apply the mind and see what is the best way to secure.
Yes, my lord.
Because right now we don't know what is his ID card.
I think that will be better, my lord.
And then if required, the IO can also assist the court in this regard there. No? Yes, you want to say something?
My lord, the order was passed in September, and still we cannot execute the bail bond so yet till now.
Yes.
We had approached many times, even orally.
Very
to the-
well. Now I'm giving a direction.
Yes, my lord. If the conditions may be set. by
I
the
am
judge.
not going to alter the third condition here. We don't know what is this Myanmar identity card that you have, and as stated by the public prosecutor, now there is some ID card given to the Myanmar refugees by the government of Mizoram. So you should have had this.
My lord-
How you don't have this?
Annexure, we had in the annexure 1A, 11A is the ID.
Yes, this is in
a different script.
Different script.
My lord, it just in case, like, supposing it presuming that he absconded, then we can like trace it.
We don't know. Let the trial court look
Yes, ma'am.
into
Let the
it.
trial court decide on that.
How do I know? The PP also doesn't know here. How she will know? She cannot read this.
Refugee ID, my lord, we had already tried, but then
So where are those papers?
we had tried, but then they said they don't issue anymore. They issued like 2-3 years
Where
back.
have you said that in your petition?
We have not stated
Then-
that. That's why
then-
we had asked for this.
No, but you see, Miss Fenai, these things has to be here.
Yes,
That
my
you
lord.
had asked for the refugee identification number, that it was not given to you. Where are those averments? Those particulars are not there. I cannot simply blindly convert these bail conditions in an NDPS matter. This court has to be satisfied that the conditions are such, because it should not be also that for name's sake we give bail conditions.
Yes, my lord.
Isn't it? There has to be a balance. Now, you are not going to give any ID cards, your even your surety, we don't know the actual relationship, nothing is there on an affidavit we are allowing.
Yes, my lord.
So it is difficult.
I understand, my lord.
So we'll send it to the
Yes,
trial
madam.
court.
Yes, let them reconsider.
Heard MS Fenil, Learned Counsel appearing for the petitioner. Also heard MS Linda, Learned APP for the state respondent. Learned PP, huh? By filing this application under section 528 BNSS, read with section 483 BNSS, comma, the petitioner is seeking modification of the bail conditions imposed by the learned judge of Special Court of NDPS Act Aizawl by order dated 17/9/2025 in bail application number 353 of 2025. It appears that the petitioner was arrested in connection with NDPS case number 197 of 2025, arising out of Aizawl PS case number 276 of 2025, registered under section 21B of NDPS Act 1985, for alleged involvement in connection with seizure of 123.08 grams of suspected heroin, full stop. Arrest date to Diniba on 17/7/2025. Thereafter, the learned special judge of NDPS Act Aizawl was pleased to grant bail to the petitioner with the following conditions. Page 2128. MS Fenil, Learned Counsel for the petitioner, submits that that the petitioner, being a permanent resident of Myanmar, presently residing at Jungtwai, Aizol, cannot fulfill bail condition number 1 bail condition number 1, 2, and 4 as he is Myanmar national and his family members are not residing in Mizoram. She further submits that the petitioner's maternal aunt, Mrs. Lalun Feli, resident of Zongstwai Aizol, may be allowed to stand as surety as family members of the accused applicant. She further submits that since the petitioner cannot produce documents to prove his relationship with her, an affidavit in this regard be accepted as proof of familial relationship for the purpose of executing the said bail bond. She further submits that due to financial hardship, the petitioner is finding difficulty to execute bail bond amounting to rupees 2 lakhs and accordingly pray reduction of the bail bond to meet the ends of justice. She further submits that since the petitioner does not have any Aadhaar card, EPIC card, driving license, etc., his Myanmar identification card be accepted as an identity card for the purpose of executing bail bond in the instant case. Per contra, Ms. Linda, though submits that as regards reduction of bail bond condition number 1 from 2 lakhs to 1 lakh and bail bond condition number 2 as regards allowing the petitioner's maternal aunt to stand as surety as family members of the petitioner, and an affidavit in this regard be accepted as proof of familial relationship for the purpose of executing the said bail bonds. However, she opposes the reduction of the bail condition number 4 inasmuch as a Myanmar refugee is issued
Some identification
an
card.
identification
Card.
card from the government of Mizoram, by the government of Mizoram. Hence, she submits that in lieu of Aadhaar card, EPIC card, driving license, instead of the Myanmar identification card proposed card, the said identification number issued by the government of Mizoram may be accepted. Heard, perused, quotable. It appears that because of the financial condition of the petitioner, he has not been able to arrange the bail bond amounting to rupees 2 lakhs. And since he does not have a he does not have an immediate family member, the same family member, comma, he is unable to arrange the surety as family member in support of the bail condition number 2. It further appears that because of the aforesaid 2 conditions, despite he has been granted bail by this court by order dated by the trial court by order dated 17/9/2025, he has been unable to he has not been released till date. The bail bond conditions, if is too harsh, amounts to no bail in a particular case. In view of the endorsement made by the learned PP and vis-a-vis the financial conditions stated in the pleadings, this court is of the opinion that the bail condition number 1 be modified from a bail bond of rupees 2 lakhs only to rupees 1 lakh. Similarly, in view of the, no, don't say similarly, as regards bail condition number 2, within quotes, 1 surety shall be any one of the family members of the accused, and 1 surety shall be permanent resident of Aizawl, living in her owned house. The petitioner's maternal aunt, Mrs. Lulan Feli, wife of Mr. Vanliana, resident of Jungtwai, Aizawl, may be allowed to stand as surety as family members of the petitioner, and an affidavit in this regard be accepted as proof of familial relationship for the purpose of executing the said bail bonds. However, as regards the bail condition number 4, since it has been stated by the public prosecutor that an identification code is issued by the government of Mizoram in relation to a refugee of Myanmar, the same can be sufficient for the purpose of identity card. Same can be sufficient as an identity card for the purpose of executing bail bond. However, MS Fanai submits that though the applicant had applied for an identification code, however, the same has not been issued. Be that as it may, it appears that because of the bail bond conditions, the petitioner is unable to be released on bail, despite the same being granted by the trial court. This court, in the interest of justice, deems appropriate to dispose of this bail application, this criminal petition by directing the trial court, by allowing the petitioner to approach before the trial court seeking modification of the aforesaid bail conditions. Upon receipt of the same, the trial court shall consider the same in accordance with law. the entire exercise after receiving the application for reduction of the bail conditions be completed within a period of 1 month? One
My
month?
lord, before the vacation? The
Within
last
a-
working day is 15th
No,
December.
no, how can I give that? Within a period of 2 weeks thereof.
Yes, my lord.
So I have not done anything. I have said that the first two can be done, but I have left it at the discretion of the
Yes, my
trial
lord.
court, okay?
Yes.
But I have indicated it.
Deeply
So,
obliged, my lord.
disposed of.
Item 17.
May it please your lordship, I'm appearing on behalf of the state respondents number 4 to 8. We have already filed a affidavit in opposition. And however, your lordship, on behalf of the learned CGC, it is paid that they will not be filing any affidavit, your lordship.
They will?
They will not be filing any affidavit. in
CGC
opposition.
is not filing.
Yes, your lordship.
And you have filed for state?
Yes, your lordship. For the respondent number 4 to 8, I filed in the month of August 2025, your lordship.
Yes, my lord, even the respondent number 9 had filed yesterday.
Filed yesterday?
Yes, my lord. Respondent
So
number
you
9.
want to file a rejoinder
Yes, my lord.
against the affidavit filed by respondent number 9
9
and
and
state?
states. Yes, my lord.
All right. Give the appearance of everyone, and MS so and so, learned counsel for the petitioner, seeks accommodation for filing rejoinder against the affidavit in opposition filed on behalf of the state as well as respondent number 9. Relist after 3 weeks and a date to be fixed by the registry. Prayer allowed, Kuridiba.
Obliged, my lord.
I have not. Who is not going to file?
Respondent number 1.
Who is
Respondent number
appearing
one.
for one?
That will be the Miss Sangpui, your lordship. Zazi
Sangsui.
Sangpui. CGC.
So I'll record her present. Should I say that she will not be filing, or should I just leave that now?
It can be left, your lordship. Then.
All right.
Item 18.
As per the last court order, the respondent number 7 has requested me to represent him before this honorable court. So I'll be filing I have filed my power this morning. If I may be given at least a week
All
time
right.
to file affidavit.
Heard Mr. Joram Chana, Learned Counsel appearing on behalf of the petitioners. Also heard Ms. Mary L. Kingtail, Learned Counsel appearing for the contemners respondents. Ms. Mary so and so submits that that in view of the order passed by this court on 27/11/2025, the respondent contemner number 7 has also instructed her to enter appearance in the present contempt proceeding on his behalf as well. Accordingly, a power has been issued to her, which she has already filed before this court today. Right?
Yes.
Let registry verify and place the said power on record. MS so and so seeks a short accommodation in order to file the show cause reply on behalf of the respondent number 7. Prayer is allowed, relist after 3 weeks and a date to be fixed by the registry.
Obliged, my lord.
Orders, item 19.
May I please, your lordship?
I cannot see anyone. The screens are not working here. Huh? There is some internet issues. Yes, you are Miss Devi.
Yes, your lordship. I'm Miss
I can hear you, but I cannot see you.
but I can see your
Apparently, there
lordship.
is some internet issue in the court premises. Since yesterday, we are unable to, view the screen. But nonetheless, this is a bail application.
Yes, your lordship. The notice has already been
Do
issued.
you
on
have
that.
anyone from here as a local counsel?
Yes, your lordship. I have one local counsel, but he is not present at.
He should have been here, Miss Devi, because we cannot see you. And Miss Mary, you are there?
Yes.
This is NDPS
21.
21C.
21.
So you have the instructions?
Yeah, yes, we can have a hearing if it is
Only
okay.
thing I cannot see Miss Devi, and her local counsel is also not in court.
Let the local counsel be on court.
Who is he?
Benjamin Belrin Sam.
Is he
Benjamin,
here?
Your
Mr.
Lordship.
Benjamin is here. Miss Linda, Miss Mary, are you aware whether he's here?
No, well, I don't
No,
know.
Your Lordship is not
I
present.
don't know him
and
personally.
Oh, you
is
don't
not
know him
present.
I don't know him.
Now, your ground of bail is about medical condition.
No, Your Lordship, that is not that is one of the ground, Your Lordship. The main issue here is that I've been, as per the prosecution case, Your Lordship, on 22nd May 23, the seizure officer has spotted a truck and introduced himself, hearing that the driver, he jumped and fled away, and from the possession of the minor, that is a handyman, the contraband was recovered,
I
Your
am
Lordship.
having difficulty in understanding also. It's not very clear.
The voice is not clear, Your Lordship.
It's not very clear.
I really don't know what to say, Your Lordship, at this time.
No, the local council should have been here in
Should
court.
have been there, yes,
Your
yes,
Lordship,
Your
let
Lordship.
them
I
appear in
just,
person.
Huh?
Let them appear physically.
Correct. I'm fixing it on Monday. You make arrangements. You relist on Monday. Next.
Your Lordship.
Item 20.
May I please, Your Lordship?
Yes.
Your Lordship, this is a bail application file under 483 of the BNSS read with section 37
Miss
of
Linda,
the...
you are appearing? 22C. Yes.
Commercial.
What are the grounds?
Your Lordship, my ground is that, Your Lordship, first of all, my first ground is that the copy of the ground of arrest has not been furnished to the...
22-1.
Yes, Your Lordship. In support of my submission, Your Lordship, I want to submit one citation.
Mihesha,
Yes, Your Lordship. Mihir
Linda?
Rajesa.
they are alleging non-compliance of 22-1.
My lord, I have given a copy. This is the grounds of arrest which was furnished at the time of arrest.
I think it is mentioned.
Yes, Your Lordship, but if the ground of arrest has been written in English, Your Lordship.
I
My
think-
client being layman do not understand the word
Huh?
English, my lord.
But it has been explained to him in the language known, my lord, at the last para.
Grounds of arrest and right to bail has been explained to you in the language known to you. This is there.
Moreover,
Sorry.
moreover,
you
Your Lordship,
cannot, in all cases, complain of non-furnishing of grounds in a in a casual manner. The ground of arrest indicates that you have been informed that you've been arrested on such and such date at such and such date for sale, purchase, possession, transportation, abatement, psychotropic substance in violation of Section 8C of NDPS Act so and so. In case you are arrested, grounds of arrest and right to bail has been explained to you in the language known to you, and you have signed in English. Your signature is there. You are Ahmed Hussain.
Ahmed Hussein, Your Lordship.
Huh?
Ahmed Hussein.
Huh?
And Your Lordship, I have been charged under
This is your
section...
signature. It's there.
Your,
You understand?
Your Lordship, may I have one submission? Your Lordship, if you... that the ground of arrest has been given under 8C, but I have been charged under 22C of the NDNPS, my lord.
That's all right. You have been informed that because of purchasing, possessing, transportation, and abatement of psychotic substance, I don't find any violation. Any other ground?
Yes, my lord. And Your Lordship, may I take you to page number... My next point is, Your Lordship, I have been beaten up by the investigation agency, Your Lordship. During this time, no possession, nothing was recovered from my possession, Your Lordship, which I also denied, but still they have beaten me, and after that also, nothing was recovered, Your Lordship. Your Lordship, you can find from the statement of witness,
Where?
74, Your Lordship.
Huh?
Page number 74. The English translation is in page number 75. Third para, Your Lordship, counting from the last 1, 2, 9. The third para from however.
Yes.
Yes, so, Your Lordship, may I read, Your Lordship?
Yes.
Your kindly permission. However, they denied and said that they have no knowledge about the seized article.
No,
We
no,
question
you're reading at which page?
75, Your Lordship.
Statement of witness Lal Fagswala.
Yes, Your Lordship. There is two civilian witnesses, which both of them has
Where
accepted
is that word? However, I don't find any however.
the
Huh?
the third, fourth para, Your Lordship. How?
Yes, yes. However, they denied.
Yes, Your Lordship. May I read, Your Lordship?
Yes.
However, they denied and said that they have no knowledge about the seized article. We questioned them again and again, and even beaten up them, Your Lordship. Even after such beating, they inform us that they have no knowledge of the contraband article. We came to the conclusion that the house owner, Van Leroy, had lied. Van Leroy is the accused number 3 in the instant case, Your Lordship, hearing. With this medical, there is also a medical report which the learned CGM College has directed to do the medical checkup. Even which the learned CGM has highlighted.
Where is this? Who have said that we questioned them again and again and even beaten up them? Miss Linda?
Civilian witness, Your Lordship.
Even after such beating, they inform us that they have no knowledge. After checking the house, we did not recover any contraband articles. Miss Linda? Now, you see, all right, ground of arrest, you have satisfied the court that it has been communicated. Now, what do you have against this accused?
My lord, the statement of the appellant himself.
Where?
Yeah, it's at page 70, my lord.
Yes.
Page 70 with para number 2. I'll read from para 2.
Yes.
With regard to my arrest on dated 3/6/2025 by excise and narcotics personnel, I, along with my friend Sadiq Pul Haq, went to Kolasip to buy methamphetamine from one Mr. Roya of Tumpuiveng. On dated 2/6/2025, we reached the residence of Mr. Roya around 7 p.m. and spent the night there. That before the date of traveling to buy meth, me and my friend had transferred rupees 12,62,000 to the bank account of Mr. Roya. That the meth was again to be sold at Karimganj. I requested Mr. Roya to deliver the articles to me at Reng Te Tlang Sang. That on dated 3/6/2025, we intended to hitchhike a vehicle for the delivery of meth at Reng Te Tlang Sang.
But this is your confession, is there?
My lord,
This is the one
this statement, I denied this statement, my lord. This statement has been.
You see, but how do we know at this time? Now the section 37 rigors is applicable, and it is not that the police officer is beating you. We don't know who is this Lal Fagswala. He's a civilian.
My lord, this civilian witness is present at the time of the, as well as the investigation agency are also present at the place
But your
of
own confession is there.
But my lord, my confession has been recorded after they have beaten me, my lord.
It's police has not beaten you.
They have beaten me, my lord.
Where have you said police? They are not. These are not police officers. Lal Fagswala is a police officer. You said he's a civilian.
My lord, may I take you to page number 96, the order sheet prepared by the Chief Judicial Magistrate, my lord.
Is there any medical done of the
Yes, my
accused?
lord.
Where is that?
It's in page number 99, my lord. Point number 6, my lord. Relevant parties in point number 6. Others, then they
Page?
99, my lord.
Yes. Yes.
My lord, point number 6. Others, in it have written that ear pain, otoscopy, tympanic membrane,
No external injury seen.
ear
I
drums.
consider the accused fit to be kept in custody.
But point number 6, my lord.
Point number 6, yes.
Otoscopy, that,
Done. NAD.
yeah.
What is NAD? And it says no external injury seen. No injury. What are you showing?
My lord, in point number, there is ear pain.
Ear pain.
Yes, my lord.
There can be ear pain.
Because,
Where is ear pain? Others.
yeah.
Ear pain. Ear pains in winters. Even I'm having a ear pain.
By which they,
In the
because,
morning, I'm having a ear pain.
my lord, this
Has
has
anybody
been,
bitten
this
me?
has been pain because of, they have beaten
No,
because.
no, there is no external injury seen. If so many people have bitten you, the witness have bitten you, the excise personals have bitten you, there is no external injury seen. Your statement before the court, all accused except stated that they were beaten up by excise personnel. All accused shall be brought before Dr. Polisip for medical examination. He has medically examined and he has found no injuries. Yes, take down. Your name? Your name.
MS Smith and Moya. My lord,
Mr.
may I have
Moya.
one submission again?
Yes, yes.
With regard to section 37 of the NDNPS, my lord.
Yes.
In that position, my lord, nothing was recovered. As I have said earlier, I have been arrested from the statement of witness number, accused number 3, my lord, in which the accused number 3 have stated that.
What about your own statement?
My lord, I'll take you to that, my lord.
You have already given a statement, Mr. Moya.
My lord, let me.
Sorry.
Let me clarify one point, my lord.
Yes.
In the statement, the accused number 3 have stated that the seized article, the amount of the seized article has been transferred to me by my client. But if I take you to your lordship to the transaction period, the transaction.
Mr. Moya, am I doing trial? Am I holding trial right now?
I'm trying to prove that
I
innocent, my
know,
lord.
but I cannot go into that now. We are at the time of consideration of bail. How do I go into all these aspects? Yes, please take down. Heard Mr. Moan, huh? Mr.
My lord, may I have still one point, my lord? Last point.
What point?
My lord, in Mihir Rajesh, it have said that, Mihir Rajesh said that the ground of arrest has to be furnished.
In a language?
No, my lord. A copy of the ground of arrest to be furnished within 2 hours before production of the magistrate, my lord.
All right, fine. Yes.
But still, my lord.
Heard, Mr. Counsel, so and so. Also heard MS Linda, Leonard PP for the state of Mizoram, so and
My
so.
lord.
By way of
May I still have one more person, my lord? Violation of section 38 is there, my lord.
38?
38.
38?
Yes.
What is 38?
38 is
Offenses by companies.
right to engage a lawyer at the time of interrogation, my lord.
38?
Yes, my lord. BNSS.
Right to? That's a procedural violation. I'm not getting into all that. Section
38 of BNSS, my lord. Right of arrest of a person to meet an advocate of his choice during interrogation, my lord.
Okay, noted. By way of this application under section 37 of the NDPS Act 1985, read with section 483 of BNSS for the petitioner is seeking enlargement of the applicant of the petitioner, I. Ahmed Hussain, who has been arrested on
3 June 2025.
who has been arrested on 3/6/2025 in connection with, where is the case number? In connection with excise KLB PS case number 283 of 25, registered under section 22C of NDPS Act. Stop. The brief facts of the case, paragraph 2, page 5, Mr. So-and-so submits that the arrest is illegal as no grounds of arrest have been communicated to the petitioner at the time of his arrest, which is in gross violation of the constitutional mandate under Article 22(1) of the Constitution of India. In support of his aforesaid submission, he relies upon the decision of the Apex Court in the case of Mahisha versus so-and-so, reported in so-and-so. He further submits that the investigating authority violated Section 38 of BNSS by not informing his right to meet an advocate of his choice. He further submits that no contrabands were seized nor recovered from the possession of the petitioner. He further submits that the petitioner was beaten up by the excise and narcotics personnel along with the YMA personnel, which clearly shows that the statement of the accused was involuntarily and hence liable to be discarded for the purpose of considering the present bail application. He further submits that since the witness number 3 has clearly stated in his statement that they had recorded the videos outside the residence of the petitioner after the articles were seized. This is not required. He further submits that the statements of the co-accused recorded by the investigating officer does not indicate any incriminating evidence to establish that the petitioner has nexus or acted together with the other co-accused so as to make him liable for punishment under Section 21C of the NDPS Act. So and so. Per contra, Ms. Linda so-and-so submits that, where is that grounds of arrest? Submit that the notice issued under Section 47(1)(2) of the BNSS 2023, dated 3/6/2025, issued to the petitioner, clearly indicates that the grounds of arrest has been intimated to him at the time of his arrest. She further submits that the grounds of arrest and right to bail has also been explained to him in the language known to him. She further submits that the allegation that the petitioner was beaten up by the excise personnel is completely ruled out in view of the medical examinations report, in view of the medical examination which has been conducted under the orders of the Chief Judicial Magistrate, Kolasip, by order dated 4 June 2025. She further submits that the petitioner has clearly admitted his guilt at the time of interrogation and hence a clear case is made out, attracting the rigors of section 37 of the NDPS Act for refusing to grant bail to the petitioner. Heard, perused. Materials available on record. Sir. It appears from the notice issued to the petitioner on 3/6/2025 on the date of his arrest by the arresting officer that the grounds of arrest has been clearly informed to him. It is further apparent from the grounds of arrest placed before this court by the learned public prosecutor that the same were also explained to the petitioner in the language known to him. It is further apparent from the aforesaid notice that he was also clearly explained of his right to bail in the language known to him. That being so, this court does not find any violation of the constitutional statutory mandate under Article 22(1) of the Constitution of India being violated in the instant arrest of the petitioner. Hence, non-compliance of the mandatory statutory safeguards under Article 22(1) fails. It appears from the statement of the petitioner recorded by the investigating officer that he has clearly stated that he, along with his friend stroke co-accused, went to Kolasib to buy methamphetamine from one Mr. Ruya, and on 2/6/2025 they reach his house at about 7 p.m. and after spending the night there, they also transferred rupees 12,62,000 to the bank account of Mr. Ruya for purchasing the contraband articles, and after receiving the said money, the contraband were handed over to them for delivering the same to were delivered.
In the statement, they have stated that as they were about to leave.
এইখিনি লাষ্টৰ খিনি কাটি দিয়া, এই পইচাটো দিয়া বুলি ক'লা নহয়। They spend the night বুলি ক'লা। However, before the date of traveling to buy the contraband articles, they transferred an amount of rupees 12,62,000 to the bank account of Mr. Ruya. Thereafter, they requested Mr. Ruya to deliver the contraband articles to them. On 3/6/2025, when they were intending to hire a vehicle for the delivery of the contraband articles, Mr. Ruya informed them to leave his residence as soon as possible and that the contraband will be delivered some other day. However, as they were about to leave, the excise and narcotics personnel entered the residence and inquired them. Where is the co-accused? Co-accused is, what is the name of the co-accused?
The next page, my lord, 71.
May translation on the next page. 71 in. Okay.
It seems he has supported. My friend had made a bank transfer. It appears from the statement of the co-accused that he corroborates the statement given by the petitioner. It appears that though the petitioner has informed the learned Chief Judicial Magistrate that he and the co-accused were beaten up by excise personnel, the Chief Judicial Magistrate, by order dated 4/6/2025, had sent them for medical examination. A perusal of the medical examination report in respect of the petitioner appears no external injury seen by the medical officer except ear pain. The allegation of being beaten up by the excise personnel appears not to be correct. That apart, it is clear from the statement of the petitioner that he had transferred an amount of so and so for buying contraband articles. At this stage, what is the stage of investigation?
Your Lordship,
Charge sheet has already been submitted.
and witness number 1 has been cross-examined, Your Lordship.
It appears that charge sheet has already been submitted and the trial has, in the meantime, commenced. It further appears that there are how many witnesses?
7 witnesses.
There are
Your Lordship.
total 7 prosecution witnesses, out of which one witness has already been examined. The test, in order to, the test to apply in a case seeking bail under Section 37 of the NDPS Act relating to an offence under Section 22C is whether there are reasonable ground for believing that the accused is not guilty of such offence and that he is not likely to commit any offence while on bail. Considering the materials available on record, it appears that there are reasonable grounds for believing that the accused is guilty of the offence at this stage. That being so, the bail prayer stands rejected at this stage. Sorry.
Yes, much obliged, Your Lordship.
Item 21.
Please, Your Lordship.
Yes, Mr. Joram Chana.
This is an application for
Condonation.
condonation of delay.
How many days?
2,226 days. but 226 days.
2,226 days.
Yes, my lord. But the actual, no, 2,552 days, my lord.
Objections.
You want to file?
Yes,
My lord, the
All
actual
right.
delay.
As prayed for by Mr.
Tila Sekimaman.
So and so, learned counsel appearing for the petitioner, released after 2 weeks to enable the respondent file objection to the condemnation sought for.
Obliged.
Obliged, my lord.
Hearing list, item 2.
English item 2. All right. None appears on call, relist after a week on a date to be fixed by the registry. Yes.
My lord, I think I'll make a mention on item number 5, part 2, my lord.
Yes.
Mr. Lalramtong is also nowhere to be found, my lord. If this matter can come up after vacation.
All right. In item 5, as prayed for by MS Linda, so and so, relist after the ensuing vacation on a date to be fixed by the registry.
Item 11.
Item 1 is gone. Item 11. None appears on call, relist after the ensuing vacation on a date to be fixed by the registry. Anything else?